welcome to NAMPA TV. We are honored to have the Deputy Executive Director in the Office of the Minister of Justice, Ms. Gladice Pickering, to answer some questions on the new Combating of Rape Amendment Bill, which is set to be tabled in Parliament. Welcome, Mrs. Pickering. We are very honored to have you today.
Thank you.
When is the Minister of Justice, Honorable Sacky Shanghala, expected to table the Combating of Rape Amendment Bill of 2018?
This bill is anticipated to be tabled in Parliament towards the end of September, beginning of October. Of course, we have received Cabinet approval for the amendment, and the draft has been finalized by our legislative drafters. It is now due to be scrutinized by the Cabinet Committee on Legislation, and if it is approved at that stage, it will be submitted to the Attorney General for certification, whereafter it will be tabled. So we anticipate this process to take place during towards the end of September, beginning of October. But the tabling will definitely be done during the session of the Parliament.
Yes, during the 6th session of the Parliament, that is. What are the significant provisions in the new bill, and why was it necessary to amend the current Combating of Rape Act of 2000?
The significant provisions in the new bill is centered around the approach and handling of victims and how they are treated in court, and also with regards to bail for the alleged offender. And it is also centered around the new increased penalties with a minimum prescribed penalty that will be applicable to a wider range of circumstances and perpetrators. And the new bill also aims or seeks to release a little bit of pressure on the state when it comes to the burden of proof. The current act, the burden of proof in terms of the current act is extremely challenging when it comes to proving rape matter beyond any reasonable doubt, which is the burden of proof in criminal cases in our legal system. So we aim to alleviate that burden a little bit by making provision for certain circumstances to be, or certain requirements that were in the current act at least, to be taken out. For instance, we've made provision for certain requirements on the rupture of the hymen, etc., to be excluded, so that is not a strict requirement for the magistrate to take into account, and the state doesn't have to prove that beyond any reasonable doubt when proving a rape case. So the burden of proof is definitely impacted on. We are trying to make it a little bit less cumbersome for the state, and then also the minimum prescribed sentences and the jurisdiction of the regional court to be able to sentence irrespective of the jurisdictional limit of the court, and also then to focus more on the victims in these cases.
Yes, this will surely be appreciated. I wanted to ask, the proposed act is described to be centered on the needs of the victim. Could you please provide us with insight as to how rape survivors will be protected in the envisaged legislation?
Rape survivors are usually, what is currently happening is that rape survivors are treated many times as a normal witness in the court. Many of them are not acquainted with the court setup, they are not comfortable, and they feel intimidated, and therefore, and this usually or often impacts on their ability to testify freely and openly. Now, we have victim-friendly courts in Namibia, and we have adjusted our physical court settings in a manner that makes it victim-friendly, where we have one-sided panels that will allow the victim not to see other people in the courtroom, etc. We have child-friendly court facilities, not at every court in the country, but at least at some courts, and we are trying to bring that in for each and every court facility in the countries, that we have victim-friendly facilities. Now, if in terms of the amendment bill, a witness, especially a survivor of rape, will be oriented, will go through an orientation session with the relevant stakeholders, including the prosecutor, if necessary, a social worker and other officials, who will take the victim through the process and familiarize the victim with the court facilities, etc. That is just one aspect of making the process more victim-friendly or survivor-friendly. Another aspect is when it comes to bail, the granting of bail to the alleged perpetrator. Now the onus rests on the state to inform the victim that a bail application will be brought to court, when it will take place. Very often they are required to even testify when the state opposes the granting of bail, etc. What will happen now is that when an accused person, who then becomes the applicant in a bail application, files his or her application in court, they will have to prove that indeed the victim was notified, and that the victim has indicated, and this is already actually happening in practice. So we are still deliberating on that draft provision as to how this will play out in practice. However, the bottom line and the rationale behind that amendment is that we should be extremely vigilant when it comes to the granting of bail and notifying the victim of either that the bail application is brought or that the accused person has been released on bail. Because many a times the accused person is released on bail and the victim is unaware of that. And that is what we are trying to avoid.
Yes, I'm sure the listeners will appreciate some of these changes. Does the new Combating of Rape Act make provision for instances where a guardian is said to be complicit in the rape of a minor?
The minimum prescribed sentence that the new amendment bill aims to introduce is applicable, or it serves as an aggravating circumstance when a person, I would just like to draw the attention of the listeners to the proposed provision, and of course I would like the listeners to take note of the fact that this is just a draft bill at this stage. There might still be some amendments before it is tabled in Parliament, but what we anticipate is that it should read something like this: any person who is convicted of rape under this Act shall, subject to the provisions of subsections 2, 3 and 4, be liable in the case of a first conviction to 10 years, which is an increased time period, or 15 years under certain circumstances. And where we really pay attention now to an increased penalty is where the complainant is under the age of 18 years and the perpetrator is the complainant's parent, guardian or caretaker, or is otherwise in a position of trust or authority over the complainant. So whilst it is not explicitly written like that in the amendment bill, it is also not excluded.
Yes.
So there is also the provision where a person might be an accomplice, and that accomplice might of course include a parent, guardian or person in trust of the minor children, the minor person who is regarded as a person below the age of 18 years. So yes, we are making provision for attempted rape, conspiracy and incitement to rape. Yeah.
Yes. Yeah. What you read for us, we can clearly see that it does spread out and it does accommodate those factors. The new act prescribes that sentences for rape when an accused is found guilty be the same as a sentence for an accused who is guilty of attempted rape. Can you please explain why this is the case, when some may argue that the two crimes differ in severity and harm done to the victim?
Yeah, in this regard, we aim to at least introduce that the minimum sentence, and that is important for listeners to understand, that the minimum sentence be applicable to both instances of attempted rape and rape. Now, the maximum sentence will of course differ, and what we are focusing on here is that there is that element of intent. So the perpetrator had the intention to rape. What the circumstances are that prevented him from carrying the act out fully, we don't know. The act, it might have been interrupted by someone who intervened or came to the rescue of the victim, or whatever the circumstances may be. That will be for the court to take into account in sentencing. But at least the minimum sentence should be applicable to both types of instances, because the intention to rape is present in both instances. And the purpose of the ministry, or the Ministry of Justice, has embarked upon this amendment bill because we would like to introduce more deterrent factors. We would like to make it easier for the court to convict, or for the state to at least prove its case, and we would also like to impose more deterrent factors, and that is one of the deterrent factors which we aim to bring in.
Thank you. In terms of procedure in a trial, the new Act proposes that rape complainants be notified of the outcome of bail hearings or the intention of an accused to apply for bail. Could you please be so kind as to inform our viewers how the justice system seeks to empower victims with the proposed changes?
So as I've said earlier, the victim or the survivor of rape should at all times, in terms of the new amendment bill, be informed about the status of the case, whether an application is lodged, if the application was successful or unsuccessful, and what the conditions are that are attached to the granting of bail, if bail is granted. So what we would like to bring about is that the victim should be able to decide on the and not just to decide, but the victim should be empowered to take certain decisions that will also be in his or her best interest. So if the victim is informed about the release of an accused person on bail, then the victim, and what the conditions are attached to that release, then the victim will know how to act if one of those conditions are not complied with, or to be more vigilant in whatever conduct he or she engages in, and especially when a minor child is involved. It is critical for the guardians or the caretakers, parents of these children, to be informed so that they can know how to take care of these minor children, better to inform schools about what they should be on the lookout for, etc. So this is absolutely to empower the victim to be informed and to take an informed decision on his or her own actions and that of the perpetrator in the event of the breach of conditions of bail.
Thank you very much. I think our viewers have been informed of this new bill, and I think they will be watching on TV when it is tabled. I also think they would have been informed of the different aspects that it entails. As we close off our interview, would you like to inform our viewers on any other significant changes made to the Act which are of interest to society?
The amendment bill, as it is now, it is not very long. It really focuses only on the issues that I have mentioned, and we would really like the nation to know that we are extremely concerned about the high incidences of rape, especially rape of minor children, and we would like to convince Parliament, the lawmakers, that these proposals are in the best interest of the survivors of rape, the victims or survivors of rape, and that we are proposing these amendments taking into account the constitutionality of each and every provision. So we have really taken care of the constitutionality aspect, and we would also like to inform the nation that although we put in place good laws, we might even have the best laws in Southern Africa on rape, it is still not going to solve the problem entirely. Legislation is but one aspect of curbing or combating rape. We need our communities to become more involved. We need parents and caretakers and other persons in charge of minors to be more vigilant. We need to pay close attention to other socio-economic elements and conditions that give rise to this evil that is really tainting the name of our country right now. So we are really hopeful that we will succeed in this endeavor, and we plead with the nation to support us in our initiatives.
Thank you very much, Ms. Pickering.